Good morning. We are General Counsel and we are currently in our 6 months of our practice. Okay, let us introduce ourselves first. My name is Nayli.
My name is Ms. JING.
My name is Mr. Kokshan.
My name is CHEE.
Good day, Senior Counsel. My name is T1.
Good morning and nice to know you guys. So first, let me introduce my name and also my partner. So my name is Miss Shazmi, and beside me,
And my name is Natasha.
so we are your senior counsel. So for today, we want to hear about your case and your research today.
Okay, Nayli, you can start.
So, today we will present our case, the humidifier disinfectant scandal that happened in Korea. The fact of the case occurred in 1994, where a Korean company named Yukong introduced the first humidifier sanitizer product. Yukong later transferred its business to SK Chemicals, which continued manufacturing the humidifier sanitizer solution and its chemical ingredients. In 1996, Company Limited, a local company, launched its own version of humidifier sanitizer. By 2001, it was acquired by Reckitt Benckiser, becoming Reckitt Benckiser. Over 20 companies, including Reckitt Benckiser, SK Chemicals, were involved in supplying, manufacturing, and selling the product across the South Korea. These disinfectants become household staples, especially during dry winters. By 2011, reports of unexplained illness and deaths began to surface. One victim, Serling Kim, was diagnosed with interstitial lung disease after using Reckitt Benckiser's product. Investigation by the Korean Center for Disease Control and Prevention revealed that the products contain toxic industrial chemicals such as PHNG, CNIT, MIT, and PGH, which are harmful when inhaled and can cause lung fibrosis. Despite nearly 8 million users, the Korean government officially recognized there are 530 victims and 146 deaths, while civil groups estimate over 1,800 victims and 266 deaths. In 2016, prosecutors charged 4 executives involving Reckitt Benckiser CEO with negligent and false advertising the humidifier sanitizer. Criminal court sentenced the former head of the local Reckitt Benckiser unit to 7 years prison and the CEO to 6 years. SK Chemicals executives also received 4 years prison terms. In civil court, Reckitt Benckiser and its supplier Heavy Chemical were ordered to pay 5 million won to Kim victim, and Reckitt Benckiser contribute over 70 billion won to a national relief fund for affected victims. The CEO publicly apologized and compensation plans were announced for the most clearly affected victim. Hence, this strategy remains one of the South Korea's worst public health disasters and a painful lesson in corporate responsibility and product safety.
Interesting. So, based on that case, what kind of issue you can observe? And was there any act of corporate misconduct or contravention of law done by the company or its director?
First and foremost, the first issue was negligence of the company to the duty of care to the consumers. The failure of the diligence whereby the OPSI launched a PHMG-based disinfectant without conducting a research of safety prior to the product inhalation toxicity, despite the company in fact acknowledging the industrial risk of its toxicity. Thus, this amounted the company failure to a reckless decision making. Therefore, the senior executive and the CEO of the company, Shin Hyun-woo, held by prosecutorial charges under involuntary manslaughter by the conduct of criminal negligence. Nevertheless, the Korean law does not clearly interpret the director's fiduciary duties, unlike Section 213 of the Companies Licensing of Malaysia, which the compliance of director to exercise reasonable care and act in good faith for the company's best interests. Yet, OPSI senior management undoubtedly did intentionally disregard the possibility of deadly consequence by them in fact did not conduct a safety test of the product beforehand, thus breaching the moral duty and ethical responsibilities of a company's duty in criminal corporate.
A very comprehensive insight. Well, based on your research, what are your recommendations for legal actions that should be taken against the company and corporate officer involved against the company and corporate officers involved in the scandal? And tell me more.
Good day, Council. Based on our review of the matter, I would like to present company, director, and policy level recommendations to address the current issues and ensure full legal compliance moving forward. At the company level, strict adherence to the Companies Act 2016 is critical. Under Section 213, subsection 1, the company must act in good faith and in the best interest of the company as a whole. This means strengthening internal controls, especially in high-risk areas like procurement, data protection, and product safety. If hazardous products are involved, immediate remedial actions such as recalls, public notifications, and compensation must be undertaken to mitigate harm and fulfill the company's duty of care. Additionally, we must ensure that there is no conduct that can be seen as oppressive and prejudicial to minority shareholders, as prohibited under Section 346. If such conduct is identified, full cooperation with investigations and compliance with any resulting court orders is essential. The company must also avoid fraudulent trading per Section 540, which could lead to personal liability for those involved. At the director level, they are bound by fiduciary and statutory duties. Under Section 213, subsection 2, directors must exercise reasonable care, skill, and diligence. Section 221 subsection 1 requires them to disclose any interest in contracts. Non-disclosure or negligence, especially in matters like product safety, can attract personal liability. In serious cases, Section 346 subsection 2 allows the court to act against the directors involved in oppressive conduct. Removal under Section 206 subsection 1 and reporting to the SSM for disqualification under Section 199 should also be considered. At the policy level, I recommend a full review of internal policies to ensure alignment with the Companies Act 2016 and corporate governance best practices. Policies on risk management, financial transparency, and whistleblower protection, particularly under Section 587A, should be strengthened. Regular audits, legal training, and updates to statutory registers are also crucial. Finally, I recommend engaging external compliance experts to support the review process and ensure our internal frameworks remain effective and legally sound.
I'm going to clarify on the legal analysis for the oxy-humidifier disinfectant scandal. Under Section 213 subsection 1, Section 213 subsection 2 of the Companies Act 2006, Section 215 subsection 1, under Section 215 subsection 2, subsection A and subsection B of the Companies Act 2016. The case that clarified the director's duty of care towards the company is the case of Hathaway against K. Mary and others in 2022. Next, I'm going to explain on the issue if oxy-humidifier disinfectant scandal happens in Malaysia, what offences are committed under the Companies Act 2016? The director of Oxy Racket Mechanism failed to exercise his power for proper purpose and in good faith for the company's best interest under Section 213 subsection 1 of the Companies Act 2016. This is because the director paid bribes to the professor in Seoul National University to manipulate the research to suit the taste of the perpetrator and use the result as false evidence. This action not just destroyed the reputation of the company, also exposed the company to a greater interest, which is not conducive for the company's long-term development. Thus, this action is done in bad faith and it is not for the company's best interest. Furthermore, the director failed to exercise reasonable care, skill, and diligence under Section 213 subsection 2 of the Companies Act 2016. After knowing the fact that the humidifier disinfectant would have inhalation toxicity, the director still ignored the seriousness of it and sold it to the company. This action reflects that the director failed to use his knowledge and experience, same to other directors, to manage the risk of the product effectively. So, it is against Section 213 subsection 2 of the Companies Act 2016. Moreover, under Section 215 subsection 1 subsection B of the Companies Act 2016, the director of Oxy Racket Mechanism may rely on information, professional or expert advice, opinions, reports or statements prepared by the experts that believes on reasonable grounds to be within the person's professional or expert competence. For example, in his case, is the professor in Seoul National University. However, the director failed to make his decision in good faith under Section 215 subsection 2 section A of the Companies Act 2016. This is because the research is carried out to suit the taste of the perpetrator and use the result as false evidence, just to mark the humidifier as a harmless to the human body and safe even when it killed humidifier made. This action has proved that the decision made by the directors is in bad faith, as he is not taking into account about the reputation of the company and the effect that the company will be facing after the selling of these toxic humidifier disinfectants. Since under Section 215 subsection 1 subsection B of the Companies Act 2016 allows directors to rely on expert or professional advice in the course of exercising their duties, hence the court in the case Ng Kiat Wei against K. Mary and others held that the plaintiff failed to prove that the first to the 6 defendants had no reasonable grounds to believe that the company's professional financial advisors were incompetent. There were reasonable grounds to believe that the completed properties ought not to have been classified as inventories in AFS 2017 and 2018. Hence, applied the same principle to the Oxy's case, since from the intention of obtaining the toxicity report is to suit the case of the perpetrator and use the result as false evidence, it is shown that the director of Oxy Racket Mechanism had no reasonable grounds from the beginning to believe that the toxicity report generated by Seoul National University to be true in proving the humidifier disinfectant is harmless to human body and safe for children. Next is the state guilt for corporate disclosure under Bursa Malaysia listing requirements. Paragraph 9.03 with paragraph 9.04 and paragraph 9.1. For example, Bursa Malaysia Securities Berhad had publicly reprimanded SPAG Consolidated Malaysia Berhad and its directors for breaching the Bursa Malaysia Securities main market listing requirements. Next, let us back to the issue If oxy-humidifier disinfectant scandal happens in Malaysia, it is against the listing requirements by Bursa Malaysia. The fact is, Oxy Racket Bank is a public listed company. Hence, Oxy Racket Bank is governance under the Bursa listing requirements if oxy-humidifier disinfectant scandal happens in Malaysia. Thus, the director of Oxy Racket Bank had failed to fulfill the paragraph 9.03 under the Bursa Malaysia listing requirements. The director had knowledge on the toxicity of the humidifier disinfectant before it was sold to the market. The toxicity of the product is definitely a material information that will affect the price, value, or market activity of the company's share that requires an immediate public disclosure. Besides, the first introduction of the humidifier disinfectants into the foreign market is also listed under the example provided under paragraph 9.04, subparagraph C of the Bursa Malaysia listing requirements and requires immediate disclosure too. After the worst biocide disaster had come to the surface, the disclosure of the commencement of or the involvement in litigation must be disclosed immediately by the Oxy Racket Bank as required under paragraph 9.04, subparagraph F of the Bursa Malaysia listing requirements. The director of Oxy Racket Bank had failed to comply with paragraph 9.1, subparagraph 1, subparagraph B of the Bursa Malaysia listing requirements. This is because under this paragraph, a listed company is required to respond to the rumor immediately when it contains correct material information. When a humidifier disinfectant disaster first started in April 2011, the director of Oxy Racket Bank denied the rumor that it was withdrawing from the business and said they are focusing on compensating for the damages by the victims. However, the truth is, Oxy Racket Bank had withdrawn their business in 2011. Although paragraph 9.16 had been deleted from the latest Bursa Malaysia listing requirements, however, the same principle do apply to the circumstances of oxy-humidifier disinfectant scandal. It was the director who intentionally disclosed a false statement on the safety of the humidifier disinfectant that leads to the loss of its investors and customers. Hence, with the support of paragraph 9.03 to 9.04 and paragraph 9.09 to 9.1, with support of example of SAAG, Oxy Racket Bank will be publicly reprimanded and its director will be fined as punishment from the Bursa Malaysia Securities.
Now, let me bring you a judgment of this case. The Seoul High Court on January 11, 2024 did what many thought impossible, where it reversed a controversial acquittal and convicted former executives of SK Chemical and ABDUL Industrial. What is their crime? The answer is distributing toxic humidifier disinfectant containing CMIT and NIT. The court declared this chemical directly responsible for fatal lung diseases. The executives were found grossly negligent, conducted no safety testing, and deceptively sold danger as safety. The High Court also rejected causation in law, where no longer must be proved harm with human trials. This is because of the consequences and scientific evidence that fall away. In a parallel civil case, the Supreme Court upheld strict liability. Corporations cannot hide behind regulatory loopholes or uncertainty. Even false labels, even mere silence can cost millions. Racket Bird's kisser was fined and its CEO was jailed. Corporate silence was deadly. This case enshrines new legal doctrines. Gross negligence is criminal. Additionally, scientific proof and victim voice matter more than legal formalities. Plus, executives can't claim ignorance while sitting at the top. Senior counsel, this is more than a Korean case. It is a global legal warning. This judgment is not just law, it is justice finally served.
So to let me know if you need anything of guidance. So yeah, good luck and good job. Bye bye.
Good luck.